very good evening and a warm welcome to Personal Finance. I'm Gugulethu, Cele. Well, tonight we speak to Madelein who's a development manager at Sage Pastel Payroll and HR. And we're going to be taking a look at the importance of having an employment contract and what this could mean for your financial standings too. So good to have you with us today, Madelein.
Hi, Gugu.
Maybe let's go back to the drawing board when it comes to employment. The employment contract, something that's often taken for granted, but why is this document so important?
Well, I think a lot of employees are afraid of the employment contract because they think it could be some sort of a sword that the employer holds over their head. But it's actually there to protect them. And employers, I think, are afraid to give their employees contracts because they think it can be used against them. But it's actually a document that should be mutually beneficial. It's there to protect the rights of both the employer and the employee as well.
Maybe walk us through the concept and the structure of this particular document, because I think given or just depending on the type of employment that you have, it could either be a one-pager or a 50-page contract, right?
That's true, yes. It depends on the environment, whether you're employed by a large corporate or a smaller business, whether you've got lots of responsibility, whether the company policy has many rules and regulations. So you can get away with a simple document, maybe an example that you get from the Department of Labor, and just keep to those simple rules, or you can get an expert to draw up a proper contract with all the company policies and rules written there.
As an employee, what should I be looking for that's in that contract that could protect me?
Well, there are minimum requirements that are dictated by the Basic Conditions of Employment Act. So if you want to go and have a look at the Act, you can actually visit the Department of Labor website and just have a quick squiz at what the minimum requirements are. There are regulations regarding overtime, leave, working hours, remuneration, and the amount of overtime you're allowed to work is all set out in the Act. So an employee should actually know that there is a minimum amount of leave that every one of us is allowed to take each year. So if your employer tells you that you only get 1 week's leave a year, please know that it's incorrect. You need to have at least 3 weeks.
So some of these things you can't dispute even though it's a contract and you sign and you actually agree to it,
Yes.
but later on you can't dispute it if it is not in correlation with the legal requirement of the country.
That's right. The contract is only legal if it complies with the minimum requirements set out by the BCA. So even if the employer requires you to work 40 hours of overtime a week, it doesn't mean you have to comply because that's actually illegal. It's an unfair labor practice.
I'm happy you said that because so often people find themselves binded by these contracts and are too afraid to fight against them because they think, look, I've signed. But clearly then, like you say, that they can get some kind of solution. What about contract employees though, or individuals who work on a part-time basis? Are there any requirements, minimum requirements that they also need to adhere to?
Well, the temporary contract is a popular form of employing people in South Africa. And quite recently, the Labour Relations Act have changed to protect those employees because I think they were taken advantage of. What employers used to do, they would employ you on a contract basis. And they will initially give you a contract that states you will be employed for 3 months. And then after the 3 months is over, they just assume that you will continue working on a month-to-month basis. And then when the employer feels like he's had enough of you, he'll just let you go. And because you've signed that initial contract for 3 months, you feel it's fair because your contract has expired. So the employee doesn't really do anything about the situation. But now the Labour Relations Act has changed to actually look at the intent. So even if the 3-month contract was signed, when that contract expires, the employer must renew the contract or let you go. The option is to appoint you permanently, but then you need to have a new employment contract in place. If the employer does not renew the contract, then the employee will be able to assume that he is now a permanent employee.
Assume?
Yes, because now the employer, his actions are actually telling the employee that he wants to appoint you permanently. So it's important for employers to either renew the contract when it expires or let the employee go.
Madelein,
you can no longer just assume that people will stay on a month-to-month basis, and employees can actually they can actually go to the employer and say, listen, you've been treating me as a permanent employee, I need to be recognized as one.
What legal action can be taken?
Well, it's easy. You can take your contract to the CCMA and they will basically handle it on your behalf.
With regard to the changes in the employment contract, do all of these need to happen in a certain time frame, perhaps before the termination of your contract, which was initially agreed upon, 3 months, a month? Or what are the deadlines that need to be put in place?
Well, the correct thing to do as an employee is to go to the employer before the contract expires. And maybe just remind them and say, you know, my contract termination date is coming up. What is the next step? Are you going to renew the contract for another 3 months? Or will you be appointing me permanently? But the employer must also be vigilant and keep track of those termination dates. So actually, the employee can stay on for a year, 2 years, 3 years after that 3-month contract is expired. And if the employer then lets the employee go without another contract in place, he can go to the CCMA and take it further.
Sure.
So there isn't a real time frame that they need to keep track of.
What about, let's put ourselves in the position of the employer for a moment, because there are quite a few entrepreneurs in South Africa and small to medium enterprises. Have you got any examples perhaps of when employees were actually using employment contracts to abuse the situation and perhaps take legal action against employers who had acted correctly?
Well, I think the most common ones are where employees don't adhere to the basic clauses in the contract. For example, working times. I know of a few companies where they allow flexi hours, but it was never stated in the employment contract. So, you know, the employer will come and say, you know what, some of you are allowed to work flexi hours, and without discussing it with everyone and agreeing on it and amending the employment contract, they just allow this practice to happen. But then for something like another employee who's not allowed flexi hours will then complain about the situation. And that can cause confusion, and it could eventually cause an argument or some form of dispute in the workplace between the employer and the employee. So the employer needs to take care of, whenever he amends some of the clauses in the contract, it has to be discussed with everyone and it has to be done formally.
And like you say, those amendments also need to be included in the original contract. Otherwise, people could always backstep and say, oh no, this wasn't agreed upon, even though verbal agreements are actually able to be held and watertight, I take it.
When it comes to the employment contract, I would suggest get it in writing. Make sure that any amendments are done on the original contract and that the two parties sign the agreement.
And the cost implications, you mentioned that you can obviously take the employer or the employee to the CCMA. Are there significant cost implications here that might impact the consumer's pocket?
There could be huge cost implications. An employee can go to the CCMA and literally ask for a year's compensation, for example. And that's a huge cost for the employer. If we come back to the temporary contract, let's say you were employed on a 3-month basis, but an hourly rate payment. But that payment might be less than you would have earned as a permanent employee. So if the employer let you go after a year and they haven't renewed that contract from 3 months up to 12 months, the employer can actually go to the CCMA and insist on all the benefits, remuneration, bonuses, any additional payments they would have been entitled to as a permanent employee, and they can make that claim.
Oh my goodness. So clearly some significant repercussions here. But before we get a quick wrap up of the conversation, the key elements as well that maybe employers need to be aware of, just to ensure that those who are their employees don't resort to labor abuse and unfair strikes and insubordination maybe when that does come up.
Well, I think the first one is important. It's important to get a contract in place. All employers should make that decision to either get a basic template and just put the minimum requirements on there, or get some professional help and do a proper employment contract that fits your company's policies and procedures. That will be the first step. The second step would be to enforce the rules and regulations you have set out in the contract. Because as soon as you don't enforce what you've set on that piece of paper, then you create the assumption that you are allowing these clauses to be amended.
What about in the case of when, sorry to interrupt you there, but when employees decide to move on and seek further opportunities, it's always a difficult question when it comes to serving notice, right?
The notice period.
Exactly.
I think a lot of employers think the notice period is there to hold on to the employee a little bit longer, and the employee feels the notice period is unfair to them. But there's actually a two-way benefit here. For the employee, it's important that they stick to the notice period that's set in the contract. Now, in the BCA, for example, the notice period can be anything between 2 weeks and 30 days, depending on the length of employment.
Mm-hmm.
So the employee who does not stick to the notice period when they terminate their services, they will forfeit the payment that they would have earned for that last period. So they won't receive their last month's salary, for example. So if you just resign with immediate effect, you can't claim that last month's salary or benefits at all, because you have now actually given it up because you did not stick to the notice period set out in the contract. And on the other side, if the employer actually discharges you with immediate effect, then they have to pay you for that additional notice period you would have worked for them. So there's a cost implication there, because the employer must keep in mind, if they don't stick to the notice period set out in the contract, then you're going to have to pay for someone's services who are not rendering services, and you'll probably have to replace that person and pay them a salary for that same period.
Sure. Quite a bit has been said. Let's potentially get a quick recap on tonight's conversation. I'm sure there are lots of people who get you in touch with you for emails and getting more clarity, Madeleine. But maybe if you can walk us through some of the key concepts that both employees and employers need to remember about employment contracts.
I think the key concepts are that make sure the contract is in place. Make sure that you have got the basic details. How much will the person earn? What will the working hours be? What are the rules regarding leave and overtime? Get that in place in the contract. If there's anything additional above the minimum BCA requirements, make sure that you've got a professional who could put that out into the contract for you. And then the third step is make sure that both parties sign the contract. It has to be a mutual agreement. It can't be a one-way street where the employer just puts down the rules and the employee has to adhere to them. It must be agreed on mutually.
Exactly. Powerful words to leave it on. Thank you so much for your time. That's where we have to leave it for Personal Finance this evening. A big thank you once more to Madelein van der Walt, who's the development manager at Sage Pastel Payroll and HR. Well, do be sure to get in touch with us. You can send any of your tweets or comments to @CNBC Africa using the hashtag Finance410 or to myself @Gugulethu on Twitter. Until next time, take care, everyone.